What are state questions 844 and 846 really for? Both proposals sound reassuring. Both would give future legislatures greater control over rules voters are not being shown today. Oklahomans will find two statewide questions on the August 25th runoff ballot. State question 844 concerns a property tax exemption intended to attract manufacturers. State question 846 concerns identification requirements for voting. At first glance, neither sounds especially controversial. Who could oppose bringing jobs to Oklahoma while protecting schools and local governments from lost tax revenue? Who could oppose asking voters to prove who they are? But those are not the questions Oklahomans are actually being asked to decide. The more important question is what happens after voters approve the appealing principle and the legislature begins writing the rules. Under State Question 844, legislators would determine how much schools, counties, career tech districts, libraries, and other local services receive when the state exempts manufacturing property from taxation. Under State Question 846, legislators would determine what identification every Oklahoman must provide for every authorized method of voting. Neither question gives voters those details now. Both proposals would amend the Oklahoma Constitution. They are being presented during an August runoff election, not the November general election. Every registered Oklahoma voter is eligible to vote on the state questions, even if the voter has no party runoff or local race to decide. Many voters may not realize that runoff elections generally receive less attention than general elections. Some independents and voters whose preferred candidates were eliminated in the primary may assume there is no reason to return. Yet the decisions made on August 25th would become part of Oklahoma's constitution. Oklahoma has offered qualifying new and expanding manufacturers a 5-year property tax exemption since voters approved the program in 1985. Property taxes do not primarily fund state government. They support local institutions, including public schools, county governments, career tech districts, libraries, health departments, and emergency services. When the state grants a manufacturing exemption, those local institutions lose revenue they otherwise would have received. The current constitutional arrangement requires the state to reimburse them for the full amount. State Question 844 would change that guarantee. Instead of requiring full reimbursement, the amendment would direct the legislature to establish a methodology for determining how much local governments and districts receive. Supporters argue that the existing system can reimburse some districts based on property valuations that are later reduced when companies begin paying taxes and challenge their assessments. House Speaker Kyle Hilbert has said legislative control could make the system more predictable and prevent some counties from receiving reimbursements that are unfair to the rest of the state. That is a legitimate issue to examine. But the proposed amendment does not contain the future formula. It does not guarantee that schools and local institutions will continue receiving 100% of lost revenue. It does not establish a minimum rate, explain whether existing commitments will be protected, or say how school districts with bond obligations will be treated. Those decisions would come later. If the legislature reimburses only 70% of the lost property tax revenue, the company still receives 100% of its exemption. The reduction falls on the school district, county, library, career tech system, or other local service. The business incentive remains whole. The local reimbursement becomes negotiable. That creates an important question. Why should schools and local taxpayers absorb part of the cost of an economic development decision made by the state? If lawmakers believe reimbursements are excessive, they should show voters the proposed formula, document the problem, and explain precisely how the new system would work. Instead, voters are being asked to transfer the authority first. State Question 846 is also presented as a solution to a problem that sounds simple. It would amend the Constitution to require proof of identity in every election and for every authorized method of voting. But Oklahoma already has a voter identification law. Voters casting ballots in person may use qualifying government-issued photo identification. They may also use the free voter identification card issued by their county election board, even though it does not include a photograph. A voter without acceptable identification may cast a provisional ballot after signing a sworn affidavit. State Question 846 would not create voter ID in Oklahoma. It already exists. A no vote would not eliminate Oklahoma's current voter identification law. It would leave today's law in place. So what does the amendment add? It places a broad identification mandate in the Constitution, applies it to every authorized voting method, and gives future legislatures responsibility for writing the specific requirements. Supporters may intend only to preserve Oklahoma's current system, but that promise is not written into the amendment. The measure does not specify which documents must remain acceptable, preserve the free voter card, or guarantee the sworn affidavit alternative. It does not spell out what identification absentee voters might be required to submit. The amendment does not tell voters whether someone living in a nursing home, serving in the military, attending college away from home, or lacking transportation would face new documentation requirements. It says proof of identity will be required for every authorized method of voting. The legislature will decide what that means. The national debate shows why the missing details matter. Texas has accepted state handgun licenses as voter identification while rejecting student identification cards. Supporters argue that handgun licenses meet state verification standards that student cards do not. But lawmakers chose those standards. A driver's license may be easy for someone who drives every day. It is less useful to an older person who surrendered a license, a disabled person who does not drive, a low-income voter without a car, or a student away from home. Obtaining a certified birth certificate, passport, or replacement identification can require money, travel, and time away from work. That does not make every identification law a poll tax. Oklahoma's current free voter card and affidavit alternative are important protections. But those protections exist because the details matter. State Question 846 asks voters to constitutionalize the requirement without constitutionalizing the protections. The Republican-backed Save America Act shows how quickly a popular phrase such as election integrity can expand into a complicated system of documentary requirements. The federal proposal would require documentary proof of United States citizenship to register for federal elections. It also would require photo identification for voting and additional identification documentation with absentee ballot applications and returned absentee ballots. Non-citizen voting in federal elections is already illegal. The practical question is how many eligible American citizens would encounter new obstacles while government searches for people already prohibited from voting. A driver's license ordinarily establishes identity, but does not necessarily establish citizenship. A birth certificate may establish citizenship but may not match the current name of a married, divorced, or adopted voter. A passport can resolve both problems, but many Americans do not have one. People registering by mail could still be required to present citizenship documents personally before the deadline. That would create additional barriers for rural residents, people without transportation, nursing home residents, and voters with disabilities. The legislation requires alternative procedures, but their effectiveness would depend upon rules and administration. Older Americans have traditionally been dependable Republican voters, but nursing home residents and seniors with mobility limitations are among the people most dependent on absentee ballots and assistance. Restrictions on who may help request, witness, collect, or return ballots can make voting harder for people who cannot travel. Military personnel and other Americans living overseas face a different problem. Time. Ballots sent from overseas military locations can take weeks to arrive. Rules rejecting ballots after Election Day, even when mailed on time, can prevent those votes from counting. Election security matters. So does ensuring eligible citizens can actually complete the process. Voter suppression rarely arrives under a label announcing its purpose. It arrives as one additional document, one fewer acceptable form of identification, one more trip to an election office, one earlier deadline, one signature mismatch, one rejected absentee envelope, or one voter roll error. Any single obstacle may appear minor. Combined, they can determine who participates and whose voice disappears. That is why voters should be reluctant to grant open-ended constitutional authority without knowing the rules that will follow. State questions 844 and 846 address different subjects. One concerns money, the other concerns voting. Their common feature is the transfer of power. In both cases, lawmakers are asking voters to approve authority without presenting the most consequential rules. How much reimbursement will a school district receive? Which identification documents will remain acceptable? Will existing alternatives remain protected? How will absentee voting be affected? The ballot does not say. A no vote on State Question 844 would preserve the current requirement that the state reimburse local entities for the full revenue lost through the manufacturing exemption. A no vote on State Question 846 would leave Oklahoma's existing voter identification law in place. Voting no would not eliminate manufacturing incentives. It would not eliminate voter ID. It would tell lawmakers to return with complete proposals that allow Oklahomans to evaluate the rules, the costs, and the consequences before placing them in the Constitution. State questions 844 and 846 are not merely about manufacturing incentives and voter identification. They are about who controls the details after voters approve the headlines. Those details will determine who receives public money, which communities absorb the losses, and how difficult voting may become. Yet none of those rules appears on the ballot. Oklahomans are being asked to surrender constitutional authority first and trust the legislature to fill in the blanks later. That is not voter approval. It is a constitutional blank check. Follow the money at wlangdon.substack.com.